agricultural land, using agricultural land for residential purposes, commercial purposes, industrial purposes. Okay. This case will touch on that topic. Okay. So this involves the developers or owners of several parcels of land located somewhere in the Philippines by virtue of a municipal ordinance, because this is within a municipality passed by the municipal council. These lands were reclassified as industrial lands. Okay? So the reclassification was done through a municipal ordinance passed by a municipal council of a certain municipality somewhere in the Philippines. These lands were reclassified as industrial lands. Okay? So nanay reclassification. The provincial board approved the land use plan of that municipality. No? So there was a land use plan for the municipality, and it was approved by the provincial board and adopted in toto, okay, fully, the municipality's ordinance with the passage of a resolution and a provincial ordinance respectively as part of their preparation for the development of the subject lands as an industrial park. Petitioners secured all the necessary permits and appropriate government certifications. So, kompleto. Permits, and government certifications. Despite these permits and certifications, the petitioner received a letter from the director of the Department of Agrarian Reform, or DAR, okay, regional office, informing him that the DAR was disallowing the conversion of the subject lands for industrial use. So there was a disallowance of the conversion of the subject lands for industrial use. Okay? But remember, the ordinance issued by that municipality already reclassified those lands as industrial. But at this point, despite these permits and certifications, the petitioner, okay, the owners or developers of a parcel of land, receive a letter from the director of the Department of Agrarian Reform, the DAR, regional office, having jurisdiction over that territorial area, so where the land is located, informing him that the DAR was disallowing the conversion of the subject lands for industrial use and directed him to cease and desist from further developments on the land to avoid the incurrence of civil and criminal liabilities. Petitioners were thus constrained to file with the regional trial court, having jurisdiction over their area, a complaint for injunction with application for temporary restraining order and a writ of preliminary injunction. Okay? This was docketed as a civil case. In an order issued by the regional trial court, ruling that it is the DAR, Department of Agrarian Reform, which has jurisdiction, dismissed the complaint for lack of jurisdiction. It justified the dismissal in this wise. A perusal of Section 20 of the Local Government Code expressly provides that the municipalities, through an ordinance by the Sanggunian, may authorize the reclassification of the agricultural land within their area into non-agricultural. Paragraph E of the aforesaid section provides further that nothing in this section shall be construed as repealing or modifying in any manner the provision of Republic Act 6657. Okay? Maumni ang kaning balaod sa DAR, Agrarian Reform. So, in an opinion of the Secretary of Justice, quoted, with respect to the conversion of agricultural land to non-agricultural uses, the authority of the DAR to approve the same may be exercised only from the date of the effectivity of the Agrarian Reform Law on June 15, 1988. It appears that the petitioners had applied for conversion on somewhere a few years ahead, and therefore the petitioner are stopped. Okay, few years after 1988, then a few years after, and thereafter the petitioner are stopped from questioning the authority and jurisdiction of the Department of Agrarian Reform. The application having been filed after the June 15, 1988 deadline, the reclassification by the municipal council was just a step in the conversion of the aforestated lands according to its purpose. So it will not fully accomplish the reclassification, but only a step in the conversion of the lands according to its purpose, no? So it will not be enough, no, that the municipal council will just reclassify it through an ordinance. Executive Order number 129-A, Section 5, the department shall be responsible for implementing the comprehensive agrarian reform, and for such purpose, it is authorized to approve or disapprove the conversion, restructuring, or readjustment of agricultural land into non-agricultural uses. The said executive order amended Section 36 of Republic Act number 3644, which clearly mandates that the DAR secretary approve or disapprove conversion are not impliedly repealed. No? In fact, under Section 75 of the Republic Act number 6657, the above laws and other laws not inconsistent of this act shall have supplementary effect. Na siya supplementary effect. Further, Section 68 of the Republic Act 6657 provides no injunction, restraining order, prohibition, or mandamus shall be issued by the lower court against the Department of Agrarian Reform, the DENR, and the DOJ in their implementation of the program. With this provision, it is therefore clear when there is conflict of laws determining whether the Department of Agrarian Reform has been exclusively empowered by law to approve land conversion after June 15, 1988, and the final ruling falls only with the Supreme Court or Office of the President. Wherefore, in view of the foregoing, the application for restraining order is hereby ordered denied, and the main case is dismissed, this court having no jurisdiction over the same. No? This is according to the decision of the Regional Trial Court. In an order, the trial court denied the motion for reconsideration filed by the petitioners. The petitioners filed before this court a petition for review on certiorari with application for temporary restraining order and writ of preliminary injunction. In a resolution, this court referred the petition to the Court of Appeals. Petitioners moved for a reconsideration of the said resolution, but the same was denied in a resolution. At the Court of Appeals, the public respondents were ordered to file their comments on the petition. 2 sets of comments from the public respondents and 1 from the Department of Agrarian Reform Provincial Office and another from the Office of the Solicitor General were submitted, to which petitioners filed their consolidated reply. Okay? So that's like consolidated reply. Later, the Court of Appeals rendered a decision affirming the order of dismissal issued by the Regional Trial Court. A motion for reconsideration was filed by the petitioners but was denied in a resolution. Hence, this petition before the Honorable Supreme Court. The following issues are raised by the petitioners for resolution. First, whether or not the reclassification of subject lands to industrial use by the subject municipality pursuant to its authority under Section 20A of Republic Act number 7160 or the Local Government Code of 1991 has the effect of taking such lands out of the coverage of the CARL, no, Comprehensive Agrarian Reform Law, and beyond the jurisdiction of the DAR, whether or not the complaint for injunction may be dismissed under the doctrine of primary jurisdiction. Third, whether or not the complaint for injunction is an appropriate remedy against the order of the DAR enjoining development works on the subject lands. Whether or not the regional trial court had authority to issue a writ of injunction against the DAR. In sum, petitioners are of the view that local governments have the power to reclassify portions of their agricultural lands subject to conditions set forth in Section 20 of the Local Government Code. According to them, if the agricultural land sought to be reclassified by the local government is one which has already been brought under the coverage of the Comprehensive Agrarian Reform Law and or which has been distributed to agrarian reform beneficiaries, then such reclassification must be confirmed by the DAR pursuant to its authority under Section 65 of the CARL. Okay? 65, 22, typo yata ni. In order for the reclassification to become effective. If, however, the land sought to be reclassified is not covered by the CARL or the Comprehensive Agrarian Reform Law and not distributed to agrarian reform beneficiaries, then no confirmation from the DAR is necessary in order for the reclassification to become effective, as such case would not fall within the DAR's conversion authority. Stated otherwise, Section 65 yun lagi, dili 22, of the CARL does not, in all cases, grant the DAR absolute, sweeping, and all-encompassing power to approve or disapprove reclassifications or conversions of all agricultural lands. Said section only grants the DAR exclusive authority to approve or disapprove conversions of agricultural lands which have already been brought under the coverage of the CARL or the Comprehensive Agrarian Reform Law and which have already been distributed to farmer beneficiaries. The petition lacks merit. After the passage of the Republic Act number 6657, otherwise known as the Comprehensive Agrarian Reform Program, agricultural lands, though reclassified, have to go through the process of conversion, jurisdiction over which is vested in the DAR or the Department of Agrarian Reform. However, agricultural lands already reclassified before the effectivity of Republic Act number 6657 are exempted from conversion. Department of Justice Opinion number 44, series of 1990 provides, true, the DAR's express power over land conversion is limited to cases in which agricultural lands already awarded have, after 5 years, ceased to be economically feasible and sound for agricultural purposes, or the locality has become urbanized and the land will have a greater economic value for residential, commercial, or industrial purposes. But to suggest, okay, that these are the only instances when the DAR can require conversion clearances would open a loophole in Republic Act number 6657, which every landowner may use to evade compliance with the Agrarian Reform Program. Hence, it should logically follow from the said department's express duty and function to execute and enforce the said statute that any reclassification of a private land as a residential, commercial, or industrial property should first be cleared by DAR, no? DAR clearance. The requirement that agricultural lands must go through the process of conversion despite having undergone reclassification was underscored in the case of Alarcon versus Court of Appeals, where it was held that reclassification of land does not suffice. No? It is not enough. In the case at bar, there is no final order of conversion. The subject land holding was merely reclassified Conversion is different from reclassification. Conversion is the act of changing the current use of a piece of agricultural land into some other use as approved by the Department of Agrarian Reform. Reclassification, on the other hand, is the act of specifying how agricultural land shall be utilized for non-agricultural uses such as residential, industrial, commercial, as embodied in the land use plan, subject to the requirements and procedure for land use conversion. Accordingly, a mere reclassification of agricultural land does not automatically allow a landowner to change its use and thus cause the ejectment of the tenants. He has to undergo the process of conversion before he is permitted to use the agricultural land for other purposes. Republic Act No. 6657 took effect on June 15, 1988. Muna siyang utlanan, no? Muna siyang boundary, ang timeline, ang deadline when pwede ordinansa lang daw. Municipal ordinance which reclassified the subject lands was passed years after 1988, and the provincial ordinance of the provincial board which adopted the municipal ordinance was passed years after 1988, long after Republic Act number 6657 has taken effect. Section 4 of the Republic Act number 6657 provides, Section 4, Scope. The Comprehensive Agrarian Reform Law of 1988 shall cover, regardless of tenurial arrangement and commodity produce, all public and private agricultural lands as provided in Proclamation number 131 and Executive Order number 229, including other lands of the public domain suitable for agriculture. Next, all private lands devoted to or suitable for agriculture, regardless of the agricultural products raised or that can be raised thereon. So, appeal siya sa scope sa Republic Act No. 6657. To further clarify any doubt on its authority, the Department of Agrarian Reform issued Administrative Order No. 12, which reads, Subject, consolidated and revised rules and procedures governing conversion of agricultural lands to non-agricultural uses. Prefatory statement. The guiding principles on land use conversion is to preserve prime agricultural lands. On the other hand, conversion of agricultural lands, when coinciding with the objectives of the Comprehensive Agrarian Reform Law to promote social justice, industrialization, and the optimum use of land as a national resource for public welfare, shall be pursued in a speedy and judicious manner. To rationalize these principles, and by virtue of Republic Act No. 3844 as amended, PD No. 27, PD 946, etc., the Department of Agrarian Reform has issued several policy guidelines to regulate land use conversion. This administrative order consolidates and revises all existing implementing guidelines issued by the DAR, taking into consideration other presidential issuances and national policies related to land conversion. The legal mandate, Part 2. The Department of Agrarian Reform is mandated to approve or disapprove applications for conversion, restructuring, or readjustment of agricultural lands into non-agricultural uses pursuant to Section 4I of the Executive Order. Next, an executive order vests in the DAR exclusive authority. Sila ra jud, exclusive authority to approve or disapprove applications for conversion of agricultural lands for residential, commercial, industrial, and other land uses. Section 65 of Republic Act No. 6657, otherwise known as the Comprehensive Agrarian Reform Law, CARL, of 1988, likewise empowers the DAR to authorize, under certain conditions, the reclassification or conversion of agricultural lands. Another memorandum circular of the Office of the President provides that action on applications for land conversion on individual land holdings shall remain as the responsibility of the DAR, which shall utilize as its primary reference documents on the comprehensive land use plans and accompanying ordinances passed upon and approved by the local government units concerned, together with the National Land Use Policy pursuant to Republic Act number 6657 and Executive Order number 129-A. Definition of terms. Agricultural land. What is agricultural land? It refers to land devoted to agricultural activity and not classified as mineral, forest, residential, commercial, or industrial land. Conversion is the act of changing the current use of a piece of agricultural land into some other use. Reclassification of agricultural lands is the act of specifying how agricultural lands shall be utilized for non-agricultural uses such as residential, industrial, commercial, as embodied in the Land Use Plan, no? CLUP, Comprehensive Land Use Plan. It also includes the reversion of non-agricultural lands to agricultural use. What is the coverage? These rules shall cover all private agricultural lands as defined herein, regardless of tenurial arrangement and commodity produced. It shall also include agricultural lands reclassified by the LGUs into non-agricultural uses after June 15, 1988, pursuant to a memorandum circular of the Office of the President, and those proposed to be used for livestock, poultry, and swine raising as provided in DAR Administrative Order number 9 series of 1993. In the case of Advincula Velasquez versus Court of Appeals, the Honorable Supreme Court held that their ruling in the Natalia case was reiterated in National Housing Authority versus Alyarde case. The Court of Appeals' reliance on DOJ Opinion number 44 series of 1990 is in order. In the said opinion, the Secretary of Justice declared, based on the foregoing premises, we reiterate the view that with respect to conversions of agricultural lands covered by Republic Act number 6657 to non-agricultural uses, the authority of the DAR to approve such conversions may be exercised from the date of the law's effectivity on June 15, 1988. This conclusion is based on a liberal interpretation of Republic Act number 6657 in the light of DAR's mandate and extensive coverage of the Agrarian Reform Program. Following the DOJ opinion, the DAR issued Administrative Order number 6 series of 1994 stating that lands already classified as non-agricultural, okay, non-agricultural before the enactment of Republic Act number 6657 no longer needed any conversion clearance. Okay, let's read the prefatory statement of the opinion. In order to streamline the issuance of exemption clearances, based on DOJ Opinion number 44, the following guidelines are being issued for the guidance of the DAR and the public in general. Legal basis. Section 3C of Republic Act 6657 states that agricultural lands refers to the land devoted to agricultural activity as defined in this act and not classified as mineral, forest, residential, commercial, or industrial land. Department of Justice Opinion number 44, series of 1990 has ruled that with respect to the conversion of agricultural lands covered by Republic Act number 6657 to non-agricultural uses, the authority of DAR to approve such conversion may be exercised from the date of its effectivity on June 15, 1988. Thus, all lands that are already classified as commercial, industrial, or residential before June 15, 1988 no longer need any conversion clearance. The authority of the DAR to approve conversions of agricultural lands covered by Republic Act number 6657 to non-agricultural uses has not been pierced by the passage of the Local Government Code. The code explicitly provides that nothing in this section shall be construed as repealing or modifying in any manner the provisions of Republic Act number 6657. It being settled that jurisdiction over conversion of land is vested in the DAR, the complaint for injunction was correctly dismissed by the trial and appellate courts under the doctrine of primary jurisdiction. The court in Bautista versus Mag-isa Viuda de Villena found the occasion to reiterate the doctrine of primary jurisdiction. The doctrine of primary jurisdiction precludes the courts from resolving a controversy over which jurisdiction has initially been lodged with an administrative body of special competence. For agrarian reform cases, jurisdiction is vested with the DAR, more specifically in the DARAB, or the Department of Agrarian Reform Adjudication Board. Executive Order number 229 vested the DAR with 1. Quasi-judicial powers to determine and adjudicate agrarian reform matters, and 2. Jurisdiction over all matters involving the implementation of agrarian reform, except those falling under the exclusive original jurisdiction of the Department of Agriculture and the Department of Environment and Natural Resources. This law divested the regional trial courts of their general jurisdiction. So, manay doctrine of primary jurisdiction. This law divested the regional trial courts of their general jurisdiction to try agrarian reform matters. Under Republic Act number 6657, the DAR, Department of Agrarian Reform, retains jurisdiction over all agrarian reform matters. The pertinent provision reads, Section 50, Quasi-judicial powers of the DAR. The DAR is hereby vested with the primary jurisdiction to determine and adjudicate agrarian reform matters and shall have exclusive original jurisdiction over all matters involving the implementation of agrarian reform, except those falling under the exclusive jurisdiction of the Department of Agriculture and the Department of Environment and Natural Resources. Okay? It shall not be bound by technical rules of procedure and evidence, but shall proceed to hear and decide all cases, disputes, or controversies in a most expeditious manner, employing all reasonable means to ascertain the facts of every case in accordance with justice and equity and the merits of the case. Towards this end, it shall adopt a uniform rule of procedure to achieve a just, expeditious, and inexpensive determination of every action or proceeding before it. Okay. Finally, the third and fourth issues, which may be summed up into whether or not an injunction is the appropriate remedy against the order of the DAR enjoining petitioners in developing the subject land, we rule in the negative. Section 68 of Republic Act number 6657 provides, Section 68, immunity of government agencies from undue interference. No injunction, restraining order, prohibition, or mandamus shall be issued by the lower courts against the DAR, the DA, the DENR, and the DOJ in their implementation of the program. Wherefore, premises considered, the instant petition is denied for lack of merit. The decision of the Court of Appeals affirming the order of the Regional Trial Court is affirmed. Cost against the petitioners, so ordered. So, nindot kayo ang kaso, no? This is about conversion of agricultural lands, reclassification of agricultural lands, no? Conversion is the act of changing the current use of a piece of agricultural land into some other use. Reclassification of agricultural lands is the act of specifying how agricultural land shall be utilized for non-agricultural uses such as residential, industrial, commercial, as embodied in the CLUP, in the land use plan. It also includes the reversion of non-agricultural lands to agricultural use. So, importante kayo ni, if you are buying agricultural land in tourist destination, no? Ang mga islands of Siquijor, Siargao, Camotes, Bantayan, sa panaubang mga isla, ha, no? Mostly mga agricultural land ang mga nadiha. Palit ka og yuta for business, magbuhat ka og hostel, homestay, hotel, restaurant, bantay-bantay ka kay imuhang mag-apply ka building permit, imong yuta agricultural land, imong gi-apply nga building permit residential, commercial, no? For business. So naay land misuse, no? So saan nimo pagkuha sa permit or if makalusot ka sa building permit, imong occupancy permit. Yeah, which imong occupancy permit required for your business permit, na? Problema na. So imo ginang tun-an with your own lawyer kung saon nimo pag-invest sa imong capital wisely when it comes to dealing with agricultural lands. So I'll see you in the next video.